to bring it this morning.
Well, look, I don't know what the allocation of responsibility is between you and your solicitors, but this is, I'm afraid, totally unacceptable.
It is, my lord, and I apologise.
As I've said, it's the first time this has ever happened to me. We are a very, very busy court here. We deal with over 1,000 permission to appeal applications in a year and over 1,000 appeals. We simply cannot function as a court if we do not have the papers in advance. Every single person who comes before this court is a matter of importance to us. They come here after they've been through other courts. They cannot resolve their issues in any other way. We want to get the right answer in the limited time available. Every case that comes before us is a very special case, and we devote all our attention to it. If we are not assisted by counsel and solicitors in preparing for this, we cannot do justice to the parties, and we'll be failing in our public duty. So I'm sorry to raise this in such a way at the beginning, but this is a very important matter, and this is a very, very serious failure. I would like your solicitors, please, to tell your solicitors that they are to write to me, to explain to me why there has been this serious omission of the duty, their duty and your duty, of your side, in relation to this matter. Will you please tell them that I expect them to do so?
I will do, my lord. I prepared the authorities bundle some time ago, and it wasn't until yesterday that I realised it hadn't been lodged with the court, for which
this case is very, very important to your client.
Of course.
And her husband. It's of absolute critical importance to them. You know, their marriage depends upon it. They've got a child. The question of them having to leave, one or both of them having to leave this country, it's very, very important. It's important for the Secretary of State. The Secretary of State's concerned about points of principle here. We have to get the case right.
Yes, my lord. There was, in addition, my lord, an email yesterday from your lordship's clerk querying whether insurmountable obstacles was the right test in view of the fact that the appellant wasn't an overstayer, as was set out in the skeleton argument. And again, I've spoken to my learned friend about this, and we're in agreement that she was not an overstayer at the time she made the application, but paragraph EX1 is still the relevant test because of the eligibility financial requirements, and therefore EX1 was the correct test applied both by the Secretary of State and by the First and Upper Tribunal. There is
well, obviously nothing about the financial requirements, either in the Home Office letter or anywhere else.
They weren't considered in the Home Office letter, presumably because the matter was rejected on the basis of eligibility, because the Secretary of State didn't accept it was a genuine and subsisting partnership. But before the first tier tribunal, the appellant accepted that EX1 was the right test for that reason. There's certain specified evidence set out in Appendix FM-SE, which was not provided or available.
What financial evidence?
Yes, there's a particular type of various very detailed requirements under Appendix FM-SC, and the appellant didn't meet those requirements, so EX1 was the correct test, although not because the appellant was an overstayer. There is the odd reference, I don't think it's so much in the first tier tribunal, but in Upper Tribunal Judge in the grounds of appeal by the Secretary of State to the Upper Tribunal, that she was an overstayer, but my learned friend has checked, and it is not the Secretary of State's position before your lordship that she was an overstayer, but that EX1 was and remains the correct test to apply.
Can we try to identify what the various potential grounds of appeal are? Because, first of all, I have in this bundle here a document which says grounds of appeal, but there are other, which is confined to one point basically, but there are other things, for example, grounds for seeking permission to appeal, which is different. So, speaking for myself, I'm absolutely not certain at the moment which of the grounds of appeal you're formally relying upon in writing.
If I can ask your lordship to turn, please, to page 10.
So it's the grounds for seeking permission to appeal, not the document that says grounds for appeal.
Which,
So if you, the item 2 in the index says grounds of appeal.
yes.
That is different, I think, is it not?
Page 10.
That's for seeking permission to appeal, but I've got...
There's a later document, I think.
There's another document.
That's at 25.
That's 25 grounds of appeal. It says in the Court of Appeal Civil Division.
Yes, those were the grounds.
That's dated the 14th of January 2017.
Yes.
And the grounds for permission to appeal don't have a date.
So which is the document we're looking at?
I was requested by the court to draft separately the issue in the case as set out on 25 at 1, 2 and 3. To put it in that way, the judge having formulated the question in relation to the subjectivity and objectivity point.
Right. Can we just see what the potential grounds are to make sure that they're covered? One point is your insurmountable objects point, where you say that in view of the findings of the judge at first instance, the judge of the upper tribunal should not, as it were, have remade the point.
Yes, there was no error of law in the judge's assessment of insurmountable obstacles.
Now, right, no error of law. Now, assuming that you're wrong about that, but that further findings need to be, in other words, there was an obstacle, but the question was that could it be overcome, or could it only be overcome causing serious difficulties for Mrs. Lull's husband. There's a question about whether the court should have remade it itself or remitted it to the first tier tribunal for further facts to be obtained, rather than just saying, well, there's air conditioning.
Yes.
Is that a point you want to take?
That, yes, and that is within the issues as set out. That
It's not in 25 to 27. I think that there should
in my skeleton argument, my lord, where it is.
You want to include that as a ground of appeal.
The wrong test was applied. It is set out.
Well, it's not the wrong test. It's that there should have been. It should have been remitted. If there were further facts to be found, it should have been remitted.
Yes, that having accepted the judge's findings of fact.
There are two stages, aren't there? The first, whether there was an error of law in the first tier tribunal's decision because the reasons were completely inadequate.
Yes.
And secondly, if that's correct, whether the upper tribunal was entitled to remake the decision, or whether they should have found further facts or sent it back or dealt with it differently.
Yes, and that in remaking the decision itself, the tribunal substituted an objective test of insurmountable obstacles and in effect concluded that nothing that could be said by the appellant's husband in particular on this issue could amount to such insurmountable obstacles.
So I'm going to deal with those as 2 points. No error of law if for one reason or another the FTT, the first tier tribunal judge, didn't get it right in one way or another, then it should have been remitted rather than the upper tribunal redeciding the matter itself as a matter of fact.
It wouldn't necessarily have needed to be remitted because the upper tribunal can and do.
I know it can, but would you not want to argue that it should have done in this case?
That's deemed by the upper tribunal to be a matter for itself, whether it chooses to
It's up to you whether you want to take the point or not.
Consider it.
You say there was an error of law in their approach anyway.
Yes. And the upper tribunal, if it finds an error of law, instead of proceeding on the reserved determination to remake it, can relist it for.
I'm going to include that. It should have remitted rather than remade it itself. Then there's the question about Article 8, because you did raise that before the first. You did raise that in your grounds of appeal to the first tier tribunal.
Yes.
They didn't feel they needed to deal with it because they decided on the rules. When it went to the upper tribunal, the upper tribunal did consider the point, but simply dismissed it on the ground of section 117b4, but that only applies when he said section 117b4 requires me to attach little weight to a couple's relationship without it's been entered into at the time the immigration status is precarious. So section 117b4 deals with a situation where it's unlawful.
Yes.
Section 117b5 deals with the situation where it's precarious,
Yes.
but that does not include in 117b5 the relationship issues. It only deals with private life, not relationship, whereas 117b4 says that what is given little weight is both private life and the relationship.
Yes.
Are you taking that point here?
Yes, in that
Are you taking an Article 8 point, are you?
yes, that it was before the Secretary of State, it was before the first tier tribunal, and that in remaking the decision on the papers, after finding there was a material error of law, the judge approached it on the basis that the appellant was an overstayer.
Yes, well, that's clear.
Misled, I think, by the grounds of appeal of the Secretary of State from the first tier tribunal.
Well, I think that is clear from 11. So have we now covered, I've now got effectively 4 points to be argued on this appeal that you'd like to argue. One is error of law. 2, question whether the upper tribunal should have remitted it rather than remade the decision. 3 is, and then 3 is Article 8, sorry. So 3 points, Article 8.
I think the second point is it's put in 2 ways, either remitted it or relisted and dealt with the facts itself, rather than simply deciding the point summarily as it did.
Oh, I see.
And from the appellant's perspective, that either one would result in a further hearing, either at the upper
Further
tribunal.
hearing with further evidence.
Yes, but whether it's at the upper tribunal or the
I
first
see
tier
that. So I
tribunal
misunderstood.
is considered.
You say that's would have been a matter for the upper tribunal itself, and for your purposes it doesn't make any difference.
It doesn't make any difference.
I understand that. Thank you very much. So those then are the 3 points that I've got. Are there any other points that you wish to argue?
No, Madam
Right, well, I better. And insofar as you need to do so, you presumably ask for permission to amend your grounds of appeal, do you? Because they don't cover all those points.
My Lord, the grounds as at paragraphs 10 and 11.
Which
Which page?
which document?
There were the 2 sets of grounds, one at 25 and one at 10.
Well, that's a bit unorthodox, if I might say so. Normally one has only one set of grounds of appeal.
I was asked, my Lord, to draft the additional issue to put it in those terms after the commission hearing.
So would we scrap those now? Or would we have both of them? Or?
They're
What do you want to have both of them?
Yes, my Lord. And the points made about the overstayer and precarious unlawful is on page 11.
Yes.
It begins at 4, but it sets out the point raised by your lordship that 117B attaches differently to 4 and 5.
Quite. It's your 4.4. It's a little cryptic, that, but anyway, it's the 4.4 point.
Yes, and it says that the reference, it was not the basis for refusal. And then the...
What permission are we talking about there? Permission to appeal to the Court of Appeal, is it?
Yes, it was from the upper tribunal.
Well, we're now talking about... It's irrelevant now.
Yes, my lord, but so 4.5 in those is irrelevant because permission has now been granted. But the relevant sections of 117B, 4 and 5 are set out in paragraphs 4.2 to 4.4.
I think I better ask then Mr. Malik what he's got to say about this, because we need to know what we're discussing on the appeal. Have you got any objection to these 3 points being raised?
Lady Lords, yes, I do. I do respectfully oppose the application to amend the grounds at this stage. I mean, of course, you have seen various pleadings in the bundle, but may I ask my lady and my lords to look at Miller and Friend's skeleton argument for this hearing. This is the skeleton argument dated 28th of September 2019. And if you look at page 2, you will see issues, heading issues in this case, and you'll see that Miller and Friend identified the issues, and you'll see that all 3 issues relate to the question of insurmountable obstacles. That's how I saw the case being advanced.
The trouble is both of you misunderstood the extent of the judge's grant of permission. Both of you misunderstood that.
Lord, the point with respect is that irrespective of what a judge says in granting permission, an appellant is entitled to abandon a point taken in the grounds of appeal in the skeleton argument.
But in paragraph 29 of your skeleton argument, you've addressed the point. So you've come prepared to deal with it.
Yes, because I
You haven't treated it as totally abandoned, otherwise you wouldn't have bothered to put that paragraph in at all. But you've given some arguments as to why you say that it was a bad point.
well, yes. I mean, I thought that it was right for me to clarify what the position is. I'm more concerned with respect to the second point that Miller and Friend seeks to make about remitting the matter to the first-year tribunal or relisting the hearing.
In view of my Lord's point, you're not taking an objection to the Article 8 point, are you?
I do for one further reason, my Lord, which is this, that you may have seen a one-stop notice that was filed by the appellant recently. There is now a child. The circumstances have now changed. So irrespective of what happens in this appeal, the Secretary of State will be obliged to look at the case again, and will be obliged to consider the updated circumstances.
Yes, but you haven't. But the Secretary of State has not done what very often he or she does, which is at any stage before the hearing of the appeal to allow the appeal because they're entitled to stay anyway. So you're not saying that the Secretary of State is bound to grant permission to.
I'm simply saying that the Secretary of State will, of course, look at the Article 8 issue again. But in terms of the second point that Miller and Friend made, of course, there is a practice direction issued by the Senate President as to the circumstances in which a case should be remitted to the first year and the circumstances in which a case should be relisted before the upper tribunal. You do not have that practice direction before you. There is some case law that I'm aware of on the subject, so I'm not sure in my respective submission whether it would be appropriate for the court to consider this important issue in this manner in absence of any.
I think the way it's put is it doesn't matter to Jones whether the upper tribunal remitted it or reconsidered it, but what I think the point she's making is that there needed to be an opportunity for further evidence on insurmountable difficulties.
Well, then of course one submission that you'll hear in due course is that where at usually when appeals are pursued at the upper tribunal and the decisions are set aside, the upper tribunal usually gives opportunity to the parties to make submissions on disposal as to whether there should be a remittal, whether there should be rehearing. So we don't know what happened in this case, whether an opportunity was given, whether there were any submissions. Looking at the decision.
Who appeared before the upper tribunal? Were they all different counsel?
No, Jones did it.
Yes. You'll see from what we see from the upper tribunal's decision is that, so far as the upper tribunal was concerned, the judge noted that the only issue was of insurmountable obstacles. It's not clear, and Miller and Friend will clarify whether an application was ever made to the upper tribunal to adduce further evidence. There is some case law on the subject that if a party wishes to rely on evidence that wasn't before the first-year tribunal at the upper tribunal, then that party is obliged to give notice to the upper tribunal make an application to adduce evidence. The upper tribunal, I add, that's perhaps the final point. The upper tribunal usually gives case management directions before listing an appeal hearing, saying that, well, if you want us to look at any further evidence, in case we set aside the first year tribunal's decision, this is your opportunity, you do that now, and if the opportunity is not taken, then the upper tribunal will proceed on the basis that there isn't anything further. Of course, my learned friend may clarify matters, but looking at her skeleton, both of us.
The way we're going to deal with this, because we're taking up time, I'm going to allow Ms. James to address all 3 points.
Yes.
We will make up our mind at the end.
Yes.
Which of those points we will allow her to raise in her grounds of appeal. But at the moment, I think that because you've addressed the question of Article 8 in your own skeleton,
yes,
it was plainly raised by the upper tribunal.
Yes.
It's now acknowledged by the Secretary of State that the upper tribunal judge plainly got it wrong in saying
yes,
that she was unlawfully here at
yes,
the time. I think you can assume it's likely that we'll at least agree with a permission for that point to be raised, insofar as that's needed.
I'm content for you to take that approach. May I simply flag the final sentence of paragraph 9 of the upper tribunal's decision, which is at page 38 of the bundle. So the only issue that was, it appears, raised by the parties was about insurmountable obstacles. So if no issue as to Article 8 is raised before a tribunal, then it's difficult to see.
It was before. He deals specifically with Article 8 in paragraph 11. So far as concerns those circumstances considering Article 8 outside the rules, he deals specifically with the issue.
But see paragraph 9, last sentence, the only issue concerns insurmountable obstacles. So it may be that there were no submissions or who knows, a
the appeal to the FTT from the Article 8 was a significant ground of the appeal to the first tier tribunal. It didn't feel it needed to deal with the matter, but it was plainly an issue. It was plainly an issue. That wasn't abandoned, was it? The upper tribunal had to deal with it.
No, you have what the judge said at paragraph 9 then. Yes. That was the only issue. I mean, it may be that was the only issue that was raised by the appellant.
Or it may have been the only issue on the application of the rules.
Yes, equally so.
Very well. Well, so we're inviting you then, I'm afraid you haven't got much time left, but we're inviting you now, Ms. Jones, to address us on those 3 issues. And we will decide in due course which of those for which we will give permission to amend your grounds of appeal.
My Lord, can I ask you to turn to the first tier tribunal's determination, which is page 52 of the bundle.
Yes, thank you.
Quite a number of the paragraphs in that determination are not going to be particularly relevant because they related to a dispute at that time of whether the marriage was genuine and subsisting. That particular part of the decision survived the upper tribunal and is no longer at issue. The evidence as set out, given by the appellant herself and by her husband and by the witnesses, is in some detail, as are the submissions made. The submissions made on the appellant's behalf then led to the findings starting at paragraph 73 on page 61 of the core bundle. The insurmountable obstacles given started being considered at paragraph, the relevant evidence to it at paragraph 88, where the judge noted that the Secretary of State had said that he wouldn't, as Mr. Wilmshurst said, he wouldn't be able to go to India because he couldn't cope with the heat. That cast doubt on the genuineness of the marriage, a suggestion that the judge rejected. And at 89 to 91, the judge found that the appellant and Mr. Wilmshurst were credible witnesses. Also, there was no reason to doubt the credibility of the other witnesses, and the most compelling evidence is that of the appellant and Mr. Wilmshurst. And in paragraph 94, it was stated that it was Mr. Wilmshurst's evidence accepted as being compelling and credible, that he would not be able to move to India as he simply would not be able to cope with the heat, and was very clear in his evidence that if his wife was required to return, he would not be able to return with her. I accept that this met the test of insurmountable obstacles to family life continuing outside the UK. The consideration of insurmountable obstacles is a relatively small part of the determination, but of course that is because all of the other issues, my lord, have fallen away.
You've got to do a bit more than that, haven't you, to give some reasons why they're insurmountable obstacles. You can't just say, well, the appellant husband has said that he wouldn't be able to cope in India, and that meets the test.
My lord, the first tier tribunal was in a position that the upper tribunal and your lordships and ladyship are not, of hearing the witnesses, hearing them being examined and cross-examined, and it's apparent from the determination that there was considerable evidence given in both chief and in cross-examination. And the judge also specifically found that they were credible witnesses.
No, it's not just a question of credibility, is it?
It's
Not just do I believe you when you say I don't believe I'll be able to go to India.
No.
Or do you say that's the test?
No, it isn't the test, my lord. And insurmountable obstacles is a high test, although defined fairly immediately after as obstacles which are not literally impossible to surmount, but would cause very serious hardship to either the appellant or partner. But it's not merely a question of I accept he wouldn't like the heat and that's an insurmountable obstacle. What the judge said is he would not be able to move to India as he would simply not be able to cope. And it is that which the judge has set out. So it's not I don't like the heat or I would find it uncomfortable. It is...
Well, actually, the judge doesn't even say that. She says it was his evidence that.
Yes, but in paragraphs 89 and 91, my lord, the judge had said that they were credible.
Well, that just means he was giving that evidence honestly.
And the most compelling evidence was given by the appellant and Mr. Wilmshurst. So yes, he was giving that evidence honestly.
But it's not a sort of, again, it goes back to the point, it's not just a question of credibility. You've accepted that. So this doesn't, it doesn't meet the test of insurmountable obstacles just because you accept that he honestly believes that to be the case.
A person who honestly believes, my lord, that he would be unable to cope and unable to move to India, if that belief is accepted as honest, in my submission does amount to insurmountable obstacles or very serious hardship for that person, whereas it might not for somebody else.
I think the problem that you're facing is, I understand what you're saying, I think the problem you're facing is that you can say that on this evidence there was plainly an obstacle for this witness, because the judge accepts that for this witness, for this person, the heat would be a problem. But what is not addressed here is the question of whether that's insurmountable. So there, you can have somebody who says, look, I can't bear the heat, and it's very, very hot in this place, and I really wouldn't like it. And then the question arises, well, is that insuperable? Are there other ways it can be dealt with, and can it be addressed? And it's that issue on which there is simply no evidence of any kind. The judge doesn't refer to any evidence, and that's why it was left open to the upper tribunal, simply to say, well, look, there's air conditioning, what's wrong with that?
A country...
Now, there may be an answer to the air conditioning.
I mean, not everywhere in India is boiling hot, for a start. Was there actually evidence about where in India they would go or have to go?
The appellant's origin is the Punjab
I'm not an expert, but I believe it's quite mountainous there, and I don't know whether it is, how hot it is. Is there any evidence about that?
There's no evidence referred to in the determination. But where it does amount to an insurmountable obstacle in my submission is that the judge accepted that the appellant would be unable to cope. And if that is true, that would cause very serious hardship.
But it's not enough as a reason just to say, well, that's what he says, and that meets the test, because I accept what he says. It's not just a question of accepting what somebody testifies to.
No, it can.
You've got to examine a bit more the basis for that evidence and whether it's well-founded.
In my submission, my lord, it can be. If the evidence given, tested in cross-examination, is accepted, which in my submission it is in paragraph...
Why was it insuperable?
I beg your pardon, my lord?
Why was it insuperable? That's what I don't understand. I accept, the judge accepted, and we are of course bound by the evidence, by the findings of the judge in the first instance, that Mr. Lowell would find it very, very difficult to cope with the heat. But where's the exploration of how that might be addressed? Isn't that an essential part of the evidential basis for saying it's an insuperable obstacle? Not just an obstacle, it's an insuperable obstacle.
Insurmountable.
Insurmountable.
My lord, in the terms of Appendix FMEX. It's to be noted that none of the points about the air conditioning and so forth are made by the Secretary of State in the submissions made before the judge. And the reliance upon the unable to go to India point was only relied upon by the presenting officer in her submissions to demonstrate that the marriage wasn't genuine. And you can see that at paragraph 63 of the determination.
Well, do you mean that there was no argument on this point?
No, there's nothing set out there about it. The focus of the Secretary of State's submissions, as my lord, you can see from them at paragraphs 52 to 63, was entirely on the genuineness of the relationship. Every single one of those paragraphs recording these submissions from 52 to 63 is about the genuineness of the relationship, and therefore, and indeed, the court might note my submissions from paragraphs 64, that my submissions to the judge were principally on the issue of the genuineness of the relationships as well. So when the judge's findings and determination also focus very much on the genuineness of the relationship, that reflects the case that was before the judge at the time, and which the Secretary of State was making as by far the most significant point.
Right. So the point you're making now, which I see the force of, if it's correct, is that the question of whether or not the heat would make the obstacle insuperable or not was not an issue that was debated in the case, in the sense that it was never challenged by evidence or submissions by the presenting officer that it wasn't an insurmountable difficulty.
Yes, the focus, as you can see from the determination, was entirely on the genuineness of the relationship. And the judge notes, for example, at paragraph 88, that the unable to go to India point was relied
which paragraph are you referring to?
88, my lord, at the bottom of page 63, was relied upon because the Secretary of State said it cast doubt on the genuineness of the relationship.
Yes, I see. Right. Well, any other points you want to make on this first, on the first point then?
No, my lord.
Right. So we then move on to the next point, which is the upper tribunal. What should it have done?
My Lord, if I can ask you to turn to the upper tribunal determination at paragraph 36, which I hope also might answer my learned friends for the Secretary of State's question about the course the judge decided to take. It is apparent from that determination that unusually for an error of law hearing it was reserved rather than immediate judgment being given, and your Lordship can see that because it says at the top of the page that it was heard on the 8th of December, but the determination was promulgated on the 8th of January.
Yes.
So it's apparent that it was a reserved rather than, as is much more common, as I'm sure my learned friend would agree, an immediate decision. It is also then apparent that the judge went on to consider on his own whether to remake it or relist it, and you can see that at paragraph 9, where Dr. Story said, I have considered whether I am in a position to remake the decision without further ado. I have decided I am. And the determination...
But was that flagged up at the hearing?
I beg your pardon?
I mean, that could come about in two ways. It could just be that the first time you know he's thinking of remaking the decision is when you get the decision, or it could be that at the hearing that was raised as to what would happen, and then he's decided that that's what he should do. So what I'm asking is, do you recall, was that something that was debated at the hearing?
It wasn't mentioned at all, my Lord, and Dr. Story announced at the end of the hearing that, exceptionally unusually for him, he would reserve it because he wanted to consider it.
How did the other difficulties that are mentioned in paragraph 10 arise? Did he ask you at the hearing whether there was anything else apart from the hot weather that you were relying on? Is that what happened? Or don't you know?
I'm afraid I can't entirely remember now. It was nearly 2 years ago, so I can't remember precisely that. It did, however, come as a surprise when the determination was received that it was not only was an error of law found, but the decision was remade. And the fact that that was Dr. Story's decision is, I'd suggest, fairly clear from paragraph 9, after his conclusion, which he certainly hadn't reached at the end of the hearing. That the
So are you saying it was wrong for him to remake the decision without further ado, as he puts it? Or should there have been an opportunity for evidence on the insurmountable obstacle? What do you say about that?
The most important aspect of deciding to remake the decision solely on the evidence before him was the fact that the determination so significantly concentrated on the genuineness of the relationship, which Dr. Story did not accept the challenge to by the Secretary of State.
I haven't followed that submission. Could you repeat that?
When the judge was considering whether he could remake the decision or not, he said that there was extensive documents in support of the appeal. This is paragraph 9, and the benefit of the judge's findings of fact on all aspects of the couple's relationship and their circumstances in the UK. And of course, my Lord, as recently I've stated, that was the focus of the determination. So the findings of fact there, although detailed, and the documents, which were extensive, a lot of that did relate to the marriage and therefore didn't assist Dr. Story in relation to insurmountable.
I mean, it could also be, what you could also make is that once he does refer to the fact there was extensive documentation and evidence, but he then doesn't actually discuss any of the evidence that there was relating to the weather being an obstacle.
No.
Because you assert that there was some evidence about that from other family members, for example, and it wasn't simply what Mr. Wilmhurst had said.
Yes, and it's correct what Dr. Story says in paragraph 10, that it was the climate, the age and the relationships with other family members in the UK which were identified as the insurmountable obstacles before the first tier tribunal.
Right, so I'm just trying to get a clear framework for your submissions. So I think what you're saying is there was no discussion about this particular aspect at the hearing.
As to what the second stage of the process should be.
If he concluded that,
Yes.
that if he was to go on and conclude that the insurmountable obstacles was not met or was not dealt with adequately by the first tier tribunal judge, what should then happen?
Yes.
There was no discussion about that.
He said, my lord, that he had not yet made up his mind.
Right, so at that stage he hadn't made up his mind. And then he comes back, and you're saying, well, he had the benefit of the FTT's findings, extensive findings, in relation to the relationship.
Yes.
But the FTT didn't say more than we've seen in relation to insurmountable obstacles.
Yes.
And you're saying that, and I think you're saying, and therefore he was wrong to think he had all the benefit of all the evidence there might be.
Yes, my lord. That he had correctly identified at paragraph 10 the insurmountable obstacles which were relied upon. But while referring to extensive documents and the judge's detailed findings of fact, it didn't take into account that most of that was about the genuineness of the marriage for obvious reasons.
But paragraph 10, he says, doesn't he, that you identified the elements that you were relying on in relation to insurmountable difficulties,
Yes,
in relation to the heat. And so the evidence before the FT and that was relied upon before Dr. Story were those matters that are at paragraph 10 in relation to this very issue.
Yes, my
And
lady.
you weren't seeking to rely on anything else, nor were you saying, or are you saying, in the plethora of documentation, there were other things about this issue which either weren't drawn to his attention or he forgot or didn't mention.
No, my lady, I'm
No.
not. But it is, of course, apparent from the first tier tribunal determination that there was evidence heard by the judge, oral evidence heard by the judge about the issue upon which he reached his findings, which obviously wasn't before Dr. Story, but I'm not stating, my lady, and I apologise if I wasn't clear, that there was a failure to refer to other insurmountable obstacles on the documentation. Because
So was the evidence about was there before the upper tribunal, for example, as referred to by my lord, was there the material of the witness statements of the stepsons, for example?
Yes, the full first tier tribunal was before Dr. Story.
Was, right.
So there were the step children, I think, 3.
Did they give oral evidence?
Only 2.
Presumably there was no note of the oral evidence, or before the upper tribunal, was there?
No, not unless Dr. Story referred to the first tier tribunal judge's own record of proceedings, but
No
if-
reference to the oral evidence.
if he had done so, it might be expected to feature in his determination. There's no...
I mean, it is a slightly curious way. The evidence, the judgment proceeds in a slightly odd way because, as we've noted in paragraph 11, he deals with the Article 8 point, the apparent hardship from the adverse decision to the claimant, and he deals then with Article 8. And it's only then that he deals with the final, no compelling circumstances in terms of in India the claimant would not be able to live with her husband without serious hardship. It's a slightly odd way of dealing with it, because you'd have thought if it were dealing with the rules that would have come before the Article 8 point.
I think he is there dealing with the Article 8 point.
I think, my lord, he
He is
is
dealing with the Article 8
dealing
point,
with
yeah.
the Article 8 point, because the rules point isn't about whether the claimant could live without her husband in India without serious hardship. It's about serious hardship if they do live in India together. So although it does repeat the phrase serious hardship, my lord, I think it's referring to the test under Article 8 rather than insurmountable obstacles.
Yes, all I'm saying is, when dealing with the rules of insurmountable hardship, you don't find that up in paragraph 10, for example.
No,
That's the point I'm trying to make. Is that one wonders whether his view about that was coloured by his finding that there wasn't an Article 8 point in it anyway.
it's. I'm not entirely clear as to what the.
But can we? So can we just deal with that? He doesn't specifically deal with the issue of insurmountable obstacle in context of heat, does he? In terms of the rules, where does he actually deal with the heat issue?
The only point he deals with it is before he set aside the decision of the first tier tribunal in paragraph 7.
So this is it. He seems to think he's disposed of the point completely at that point, not merely found an error in the first tier tribunal, but effectively found that no judge could have reached that conclusion.
Yes, Dr. Story doesn't say that in paragraph 7, but it appears it's the strong implication, my lord, because he says there's a singular failure to treat the insurmountable obstacles threshold as a high one. And then in considering insurmountable obstacles in paragraph 10, although it's mentioned that heat was relied upon,
He seems to proceed as though he's already dealt with it, because he says the only matters apart from the hot weather, and then he goes on to deal with those.
yes, and it's
So he doesn't come back and say, well, when I look at the evidence, I find as a fact that they failed to prove insurmountable obstacles.
No, there appears to be an elision in paragraph 7 of the question of whether there was an error of law in the first tier tribunal's decision and disposing of that issue altogether.
So is it right, he seems to say in paragraph 7 that there would have to be something in the nature of medical evidence?
It implies that, but again, it doesn't say there would have to be medical evidence, but it does say it was significant that there was not medical evidence.
So I'm just trying to tie together all these various different points you're making about the way he dealt with this. The first point you've made is that at the time of the conclusion of the hearing, he'd not indicated what he was going to do about any further hearing or namely to find further facts.
Yes, my lord.
That first you learnt about that was when he came back. There was no debate about that at the hearing.
No, my lord.
That's the first point you made. The second point I think you're making is that he deals, as far as the rules are concerned, with insurmountable difficulty in paragraph 7.
Yes.
And are you saying that's an adequate dealing with it or not?
It's an adequate. It is inadequate in the appellant's case in that it found an error of law where there wasn't one. And
No, but I suppose there was an error of law because the reasons weren't adequate given by the first tier tribunal. Was that an adequate way of dealing with it? So far as remaking the decision goes?
Marginal in that the reference to the previous determination does ignore all of that it was a genuine and subsisting, but
I mean, he doesn't seem to have gone through the process of asking first whether there were very significant difficulties and then deciding whether they could be overcome or not. He just elides it all into one question.
Yes, he just says there's essentially in paragraph 7
And 6 you've got to look at as well, because he says difficulty coping with heat is not in itself a serious hardship where there's air conditioning. So is he saying there it doesn't amount to a significant difficulty, or is he saying, well, it does, or even if it does, it could be overcome by air conditioning? It's not clear, is it?
I can't say which he intended.
And the air conditioning, something that presumably, well, there was no evidence about, wasn't something that Mr. Wilmhurst was given the opportunity to comment on in evidence.
No, as you can see from the first tier tribunal, there was very little either in the way of cross-examination because of insurmountable obstacles, because of the heat.
So do you take a point that if it was going to be found that significant difficulties could be overcome by air conditioning and what he calls available urban environments, then that was a point which the appellant needed to have an opportunity to address. It couldn't just be presented by the judge.
Yes, my lord, and he couldn't claim to be basing that on the findings of fact of the first tier tribunal judge, because the first tier tribunal judge didn't make such findings.
Right, so let's just see. So you're saying paragraph 6 is inadequate. Paragraph 6 and 7 together are inadequate. Is that right? An adequate treatment of the issue of insurmountable obstacle.
Yes, and fails to consider whether the issue is one that should be considered on the appellant's husband himself, or whether it's an objective issue.
I think your point. I think one of your points is looking at the first sentence of paragraph 6, or first and second paragraph, is you're saying that what the judge found was not subjective evidence. It was a finding that he couldn't cope.
Yes.
That's your primary point. Your primary point, it's not simply a statement of what he believed, but the judge accepted his evidence as to the fact. That's your primary point.
It is.
And he didn't understand that, you're saying.
Yes.
But then you're left, so I understand that point. And you're also saying, I think, so that you say was wrong, and you're also saying that certainly when it comes to paragraph 10, that, paragraph 9, that the evidence that was before the first tier tribunal was actually really all directed to the question about the relationship.
Yes.
And so when he said he had all the evidence there that he needed, the truth of the matter is there wasn't really much evidence before the first tier tribunal.
No, some of the evidence towards genuineness obviously did establish the wider family ties, but that wasn't a significant part of the appellant's case on insurmountable obstacles, because all of the appellant's then children were adult, and therefore the Article 8 relationship was in law considered much weaker. So there was some consideration of family ties, as you can see in the first tier determination, my lord, but most of that was about whether the stepchildren supported the marriage and its genuineness. But the judge failed in remaking the decision to consider in second sentence of paragraph 6, my lord, what it meant that the judge had accepted the subjective evidence that he would be unable to cope.
You say what he accepted was not a subjective belief, but he actually accepted the evidence that he wouldn't be able to cope.
Yes, my lord.
I've got that point.
Yes, in which case I will move on, if I may, to Article 8.
Yes, thank you. Article 8,
which is that the first tier tribunal, in fact, didn't make it particularly clear in the determination why it was considering the matter under EX1, because it wasn't an issue before the first tier tribunal that it must be considered under EX1 because there was a failure to meet the financial requirements. It is fair to say that it is often the case that insurmountable obstacles is considered because of the overstayer issue, and it does seem to have been assumed in this case by Dr. Story that in fact the appellant here was an overstayer.
That's clear enough, I think, isn't it?
That suggestion is set out clearly in paragraph 11.
Yes.
In fact, it wasn't just that the claimant was an overstayer. Wasn't an overstayer at the time she entered the marriage. She was still made the application within time, and therefore is even now lawfully in the UK because of Section 3C of the Immigration Act 1971, which extends leave during any statutory appeal process. And as the appellant first came to the UK in, I think, 2011, she's now been in the UK lawfully for approximately 9.5 years. I think it was April 2011, although I'd need to check the exact date.
You mean 8.5 years, do you?
Sorry?
You mean 8.5 years, do you?
Yes, I'm sorry, my lord, I do, yes. So I would therefore ask that you note that it is now agreed that...
You've got a short point. Can I just cut? So you have a short point on paragraph 11, which is he didn't address Article 8 correctly because he assumed that Section 117b4 applied,
Yes,
and it didn't apply.
no,
That's the short point.
it is, and he should have applied instead.
So what if he made that error? Then what follows from that? What should this court do?
Well, that part of the determination in itself of the upper tribunal can't survive, my lord, because it simply applies the wrong test. So when
So do we address Article 8 ourselves then, or what should happen?
if you conclude, my lord, that Dr. Story's decision is wrong and can't stand,
Well, because it was made on an erroneous basis, but it doesn't follow that his conclusion couldn't have been reached by applying the right test. Just so who decides that now? Do we send it back to him or the upper tribunal, or do we decide it?
my lord, if you've reached the position of quashing it because of the insurmountable obstacles point, then in my submission the first tier tribunal determination should stand. If, however, you quash only on the basis of Article 8 being badly considered, then the first tier tribunal's findings on insurmountable obstacles would not be a complete answer. However, there is then a highly material change of circumstance when your lordships and ladyship are considering what to do next, in that there is the birth of a British citizen child.
So what should we do next?
Allow the appeal under Article 8.
Well, we can't decide whether can we. What basis? We don't simply allow the appeal because there's a child. There's an exercise that has to be gone through of analysis.
Wouldn't it be sensible to say, can we not send it back to the fact-finding body, which is the first tier tribunal?
Yes, my lord.
Would that not be the sensible course, to send it back to the first tier tribunal? Because the first tier tribunal didn't reach a decision on Article 8, it didn't seem to have dealt with it, because it was under the rules. So wouldn't the sensible, what one must assume is that if Judge Story had come to the correct conclusion that it wasn't 117b4, but 117b5 that applied, wouldn't he have been bound in the circumstances to have sent it back to the first tier tribunal, which ought to have reached a decision on that point, but didn't think it needed to?
Yes.
Wouldn't that be what he would have done? And therefore, isn't that what we should do?
It would be open to the court either to restore it to the upper tribunal or the first tier tribunal, but it is probable that the upper tribunal would itself send it back to the first tier.
That seems likely, doesn't it?
Likely. What I couldn't say is that they would definitely do so,
People
but...
do all sorts of things. But
Sorry?
people do all sorts of things.
It
One
is
hopes that they'll
likely.
choose the most pragmatic course, and the most pragmatic course is to send it back to the fact-finding tribunal, which didn't think it needed to go into Article 8, but in the circumstances that they were wrong about, the first tier tribunal was wrong about insurmountable obstacle, would have had to have gone on to consider Article 8.
Yes, there is one point that I would make, and that it is an undoubted error of law in the first tier tribunal judge's decision, although never noticed by the Secretary of State or material, that the judge purported to allow the appeal under the immigration rules, whereas in fact the judge did not have the power to allow the appeal under the immigration rules because it's after the change of jurisdiction where it could only be considered on human rights grounds. So,
Could you elaborate on that? I'm not quite sure I followed all of that.
I beg your pardon. There was a complete change in the appeal structure under the 2014 Act, which meant that the first tier tribunal can only consider human rights and asylum issues. So, if it's considering the Appendix FMEX1, technically it is supposed to allow the appeal under Article 8 because the decision is not is in accordance with, it's not under Article 8.2 proportionate if the appellant meets the immigration rules,
I see.
but cannot actually allow the appeal under the immigration rules. And that might sound purely nitpicky.
Which is the statute provision for that?
Oh, it's the 2014 Act.
Which section is it?
Sorry?
Which section?
Well, it amended the Nationality, Immigration and Asylum Act sections 84 and 85. Nationality, Immigration and Asylum Act 2002. Sections 84 and 85, which say what grounds an appellant can appeal on. And while that might sound pointless in terms of this case, because it is an Article 8 case, it does mean you can't appeal on the basis that you meet the student rules or the work permit rules or anything which isn't human rights related.
So you're really saying...
The judge did consider Article 8.
Which judge?
The first tier tribunal judge, in effect, can only have allowed this appeal.
But there's no reference to Article 8, is there, in that judgment?
There isn't, because the judge has said the appeal is allowed under the immigration rules.
Right, but it's still a two-stage approach.
Yes.
Even under the new position, presumably. You look at it under the rules, don't you? And
Yes.
then you look at it outside the rules.
Yes, and if the person meets the immigration rules, then the appeal
Right,
should
okay.
be allowed under Article 8, because it
So
can't be
the whole
justified.
context is Article 8, actually.
Yes.
The whole context is Article 8.
Yes.
Right, is there anything else you'd like to say?
No.
Anything else you want to ask?
And
I
well,
apologise.
my only question is what's happened to the authorities?
They were given to your usher.
We've not received anything.
I think the usher gave me all of them. I beg your pardon.
I think it was the usher, I think it was your clerk.
I didn't see my clerk.
Anyway, could you collect those documents?
And a copy for my learned friend. I'm sorry, my lord, I saw a copy slide next to me and I thought they'd been given to the court as well.
Well, I think it would have been also helpful to have had the relevant rules you're relying upon. But never mind, we've got this. Thank you. But in future, if you could include the rules you're relying upon, that would be very helpful. As people do include the statutory provisions.
And the statutory provisions that are referred to in your skeleton argument, for example.
Yes, my lord.
Shall I ask him to send those reports?
It's all right, I've got them.
Any issue you want to raise about whether the rules have changed or anything?
No.
Very well, thank you very much. Yes, Mr. Malik.
Lord, may I deal with the 3 points in turn?
Very much.
Lord, on the first point, you have my submissions on the law in my skeleton argument. From paragraphs 13 to 25. And Lady and Lord will see that I have referred you to the relevant authorities on the subject. I've given the relevant paragraph numbers, and at paragraphs 21 and 22, I have respectfully put forward...
I'm just trying to find your skeleton for me. I'm not sure if that's in the bundle, is it? No, it's not. So, this is your paragraphs.
Yes, so if you look at paragraph 13 of my skeleton first, you'll see that I have referred to Agriaco, which is the lead authority on the subject.
That's paragraph 14.
Yes, 13 and 14, yes. And I've addressed the law.
It's a stringent test.
Absolutely. And then I referred to the 3 judgments of this court. I'll take you to those judgments in due course. Just to respond to a couple of points that my learned friend has made this morning. But if you then look at paragraphs 21 and 22, you'll see that I have respectfully put forward 2 formulations as to what constitutes insurmountable obstacles. And that, in my respectful submission,
This is your. What I've got is Secretary, this is your skeleton for the application for permission to appeal, is it? Paragraph 22 says, for all these reasons, Secretary of State respectfully
No.
advises the
This is the
Board
August 2019.
Is that in the file?
Is that right?
No, it's a loose document.
I don't think I've even got that. Oh no, I've got that one. Sorry. My fault. There's another one here. Yes, thank you.
Yes. So after setting out the law, you'll see that at paragraphs 21 and 22, I have respectfully put forward two formulations as to what constitutes insurmountable obstacles. This, in my respectful submission, arises from the case law, and I would respectfully invite the court to approve these two formulations. Miller and Friend has not suggested that these formulations are wrong.
Yes, thank you.
Well, when you say in the first one it would be literally impossible to overcome, that's a bit of a gloss, isn't it, on the rule EX2, because it says could not be overcome. I mean, one might be that could not realistically be overcome or something, not necessarily literally impossible.
No, absolutely, and that is the reason we have the second formulation. I mean, the first formulation, for instance, arises where it's just not possible for a person to get a visa to relocate to the applicant's country of origin. That in itself would constitute an insurmountable obstacle.
Yes.
But of course, that isn't determinative. Even if that is not the case, a person may qualify if the second formulation is met, which is if there are very significant difficulties.
All I'm taking issue with is that literally impossible might be putting it a bit high in the first point.
Do you not find it, may I just try and get something out here? Might it not be said to be rather strange that in the case of a genuine marriage entered into when the applicant was lawfully here, where the partner is 73 years of age, has never been to India in his life, it's being said that it's not unreasonable, not insurmountable for them both to, and his family are entirely here, that it's not unreasonable that he and she should continue their life in a country to which he's never ever been. Does that not strike you as slightly unusual?
There is of course a good reason for that, which is that as Miller and Friend has accepted and as she considered before the first year tribunal, the financial requirements are not met. So if a person is residing lawfully in the United Kingdom and if he meets the substantive requirements in the immigration rules, if the earnings are above a particular level.
There's no suggestion here that the husband can't support the wife, is there?
Well,
He's retired, I think, so presumably that's why they don't have earnings above 18,000 or whatever it is.
Yes, but
is that right?
That may be the case, but there are different ways in which one may meet the financial requirements.
Because we've never had to look into that. We've never had to look. That's not been an issue until it was raised here.
No.
So we've not looked into that. But just standing back from, one has to get some sort of grip on reality here. Does it not strike you does it not strike the Secretary of State as curious that in such a situation as this, there's no suggestion that they're together, they can't live together and support themselves. They're living here. They've got a loving and true relationship which is accepted. He's 73 or more now. He's 74 years old, 73 years old at the time. He's never ever been to India. That it's reasonable to expect them both to go and live in India.
Not that I do not recognize the force of what, my lord, you're saying, but the case law demonstrates that if a person is unable to meet the substantive requirements of the immigration rules, then that is the test that person must meet in order to
Maybe
qualify for.
That's why this is a case where obviously Article 8 applies.
Yeah, well, my lord, I'll make brief submissions on that, but for instance, if you look at paragraph 13 of my skeleton argument, I can take you to the authority that assists, but you'll see that I referred to the case of Junisi there, which was considered by the Supreme Court in Agriaco. And you'll see that was a case where there were, for instance, children, Dutch nationals who had lived there all their lives, never visited the country of origin, But even in that extreme case, it was said that there were no insurmountable obstacles.
But when you're a child, you're more adaptable. And especially if you speak Dutch in Suriname, you've got quite a good start on things. It's not quite the same as somebody at the age of 73 having to move to Suriname or India.
I do not disagree at all that it would be difficult. I mean, there's no question about it. The question, of course, is whether the tribunal below was entitled to find on the evidence that there were no insurmountable obstacles. And the submission that I make is that there were only 3 matters that were identified. The first, hot climate. Second, the partner's age. And third, that the partner had other family members and friends in the United Kingdom. That was all.
That was all because, according to Ms. James, this wasn't an issue as such. All the evidence, and indeed this is true in the Secretary of State's decision, was devoted to the question of the genuineness of the marriage. That's what everybody was focusing on.
Yes.
This didn't seem to have received any sort of separate, significant treatment.
Yes, Lord, I was hoping to address that issue in the context of the second point, because that is where Miller and Friends said that, well, the upper tribunal should have relisted the matter for a hearing, or should have remitted the matter to the first-tier tribunal. And Lord, I will of course address that point. But for the purposes of the first point, these were the 3 matters that were identified in the evidence. The upper tribunal deals with the first matter at paragraph 6, where the judge...
First-tier tribunal?
No, the upper tribunal's decision, page 37. So the judge says that the first-tier tribunal's treatment of the issue was not satisfactory. That, with respect, is plainly correct. The judge then gives reasons for that, and if you look at the last sentence, you'll see that the judge says that difficulty coping with heat is not in itself a serious hardship in a country ...
But is even that right? I mean, you have to go outside. You can't sit in an air-conditioned room all your life, or go into an air-conditioned garage to get your car. You have to go out sometimes, don't you? Or you're not allowed to do that.
No. Lord, if one can succeed in an appeal of this sort, in establishing that there are insurmountable obstacles simply because that person cannot cope with heat, then in my respective submission, the test would simply collapse.
Well, let's suppose in your favour that the upper tribunal was right to say that the reasons given were inadequate. It's not good enough, is it, just to go on and treat that as a sufficient basis for deciding the point on the facts adversely to the appellant, without at least giving the appellant a chance to address the point about air conditioning, for example, and if that's thought to be an obstacle, surely, if it's not something that the respondents relied on, you've at least got to give a chance to consider that before you treat that as a sufficient basis to remake the decision.
No, of course, that is an altogether different head on which on which a person can bring an appeal to this court. This goes to the fairness and of the proceedings. That isn't the point, as I understand, that was taken. But may I
well, it's not just fairness; it's also whether it was proper as an evidential basis, which it seems to have been treated as by the Judge Story, because he remade the decision, to rely, amongst other matters, on air conditioning without any evidence about that. It's just something he's come up with off the top of his head. But available urban environments, I don't know what that means, but you presumably want some evidence about that before you just go and make a decision on that basis.
Well,
I don't know whether there are shopping malls in the Punjab, if that's what he's talking about. He doesn't know either, I don't think.
Yes, the submission, my lord, is that it is for an appellant to put before the upper tribunal the evidence that he or she wishes to rely on. If that appellant says that he cannot cope with heat, then it is for that appellant to provide evidence to substantiate that assertion.
But then, isn't it? But if it's going to be put as an objection to the evidence that he can't cope with heat, that there's air conditioning, that surely is something evidentially for the respondent to come forward with.
Well, it happens, for instance, and I'll take you to an authority on the subject, where an applicant, for instance, say that, well, if returned, he would not be able to work. That is an assertion. And of course, a judge is entitled to say that, well, you haven't explained in evidence as to why that is the case, and in absence of any evidence, find that there are no insurmountable obstacles. But in my respectful submission, there is one cannot expect to succeed in an appeal of this sort by simply putting forward heat as a justification for there being insurmountable obstacles together with age. And
I mean, there was some evidence, it seems, we haven't got it, for example, that he could never even go on holiday to European countries like Spain or something because he was sensitive to heat. Some of his stepchildren or children, they gave that evidence.
yes, but
I mean, isn't that something the upper tribunal at least needed to engage with if they were going to remake the decision factually?
Well, in my submission, the upper tribunal engaged with that. But all those matters, even if one accepts everything that is being said, there's no way in my respective submission that would be enough to meet this very high threshold.
Well, why not? I mean, it's one thing, you may say, well, it's not good enough for him just to say, I don't think I can manage the heat. But if there is evidence that through his life, and he's 73 now, he's never been able to tolerate hot countries, then isn't that some objective basis on which might be treated as sufficient? But in his particular case, it is, in practice, unrealistic for him to go and live in that country.
But ultimately, that was merely an assertion. There are, for instance, no medical issues, no evidence was adduced by the appellant that he would be compelled to live in a particular part of India with hot climate. And all the upper tribunal had were these.
Are you saying? I think we're getting a slightly compressed analysis here. There are two issues, aren't there? One, is there an obstacle? And the second issue is whether that obstacle is insurmountable.
That is.
There
right.
are two quite distinct issues.
Yes.
Are you saying that the judge was not allowed to accept, no judge could accept, I think is what you're saying, the evidence of an applicant or an applicant's partner, supported by their children, that this particular applicant or the partner cannot bear a hot climate?
Such that it would be at least a very significant obstacle.
Such that it would be, well, and therefore it would be a very significant. Are you saying that no judge can accept that evidence? That they're all, I'm not talking about insurmountable difficulties now, I'm talking about obstacle. Are you saying that as a matter of law, no judge is entitled to come to that conclusion without medical evidence?
No, that those constitutes obstacle to return.
It constitutes an obstacle. No.
No, yes.
You accept that?
Absolutely.
So the focus, I understand. So the focus, and I understand this point.
Yes.
The focus is on the inadequate treatment of insurmountability.
Yes.
All right, but that at least provides us a
No.
focus. And I understand that point.
I'm grateful. So you have references to the evidence in Miller and Friend's skeleton argument, and I do say with respect that, and this is paragraphs 15, 16, and 17 of Miller and Friend's skeleton, where she has cited the witness statement evidence, and we do not have those witness statements, but that is all that we have.
Right.
And I do say, Lady and Lords, with respect, that no properly directed judge can find that those matters are sufficient to meet the test in paragraph EX1.
But that's why I'm trying to dissect this. That's what I keep on trying to do. You're saying they are inadequate to establish, and you're saying, as it were, you're by way of inference, that the burden is on the applicant to show that the obstacle is insurmountable.
Yes.
All right. Well, let's just get some structure. That's fine. I see that. So the judge didn't deal with insurmountability adequately, and in terms of the evidence that was before the judge, you're saying that the burden of proof, if I can put it like that, or the burden of persuasion, was on the applicant to show that that obstacle, which the judge was entitled to accept, was insurmountable.
Yes.
That's what it comes to, submission.
Absolutely.
Right, we've got that point. I think the point that my lord was making, and I think to some extent I was making this, is that in paragraph 6, to which you've drawn our attention,
Yes.
the judge merely assumed on the insurmountability point that air conditioning and available urban environments, which I am equally unclear about, was obviously sufficient to overcome it. And so what's being put to you is, well, how was the judge in a position to reach that conclusion? It's one thing to say, yes, you didn't prove, the judge below, if the first tier tribunal did not deal with the matter adequately. It's quite another thing for the appeal court to simply say, well, we can make up our minds because obviously air conditioning is appropriate. That's the point that we're focusing on.
Yes, so my submission with respect is that where an appellant simply says that I cannot relocate because of heat, and that's it, giving no further particulars as to why it isn't possible for that person to live in an urban environment, why it's not possible for that person to be assisted with air conditioning. A judge in my submission is entitled to conclude.
How could the judge possibly know that air conditioning is the answer to the, how could he know that? And what, as my lord has said, what are these urban environments and where are they? I mean, how is the judge able to just dismiss that there may be an insurmountable obstacle? How is he able just to dismiss that by referring to air conditioning? I mean, as I said, there's a short point, which is surely people are allowed to walk outside in a very hot climate. And you can't go around in a bubble. What happens if they want to go for a walk?
They probably can in Florida, but not necessarily. But you can't assume that.
Well, if you look at Miller and Friend's skeleton argument, paragraph 15, just to show you what was said by the appellant in evidence.
No, there's no disagreement about this. I think you've got an open door here, as far as I'm concerned. You're saying the burden was on the applicant to show,
Yes.
or at least to lead some evidence to show that it was insuperable. Then there might have been a shift in the burden. So they might have said, look, I simply can't cope at all, and air conditioning is not going to help me because I like to go for long walks. And then, no doubt, the burden would shift, and the Secretary of State would have to say, well, that's true, but then there's this reason, or you can relocate to the Himalayas, or some other place like that, and there'd be no difficulty. And then the judge would have to make up his or her mind. I can see all of that.
Yes.
But the question we're focusing on is whether the judge was, at this point, whether the judge was entitled to as it were, deal with this entire point about insurmountability by himself assuming two factors, one, air conditioning, and available urban environments. They're the only matters he mentions.
Well,
that's the issue we're dealing with.
Yes. Well, the submission is twofold. The first is again, I do apologize for repeating myself, that where an appellant simply says that I cannot put up with the heat and there is no way I would be able to live in India, full stop, that's it. The judge, in my respectful submission, is entitled to take the view that that would not constitute insurmountable obstacles in a country where...
All right, so that's a different point. So now you're saying, ignore the fact of what the judge says about air conditioning. We never had to get to that point, because all the judge had to say was, this particular applicant never adduced enough evidence to deal with this point, and therefore could not have succeeded on it. That's a different point.
I think the judge, what the judge is saying in paragraph 6 is that, well, the fact that the appellant is saying that he cannot put up with the heat is not enough, because, I mean, yes, because of what the judge then says. Just giving another example. I mean, if a person says that I cannot work in India, full stop, a judge is entitled to say that, well, there are employment opportunities are there in India, and you haven't explained why you cannot take up the work.
And taking up what the Master Rolls said, and what I think you said earlier, and what I think you just said, in effect, what you're asking us to do is to read that last sentence at the end of paragraph 6 as if it stopped after a serious hardship in a country, and ignore the examples which you say are only examples which are given afterwards, because what you're saying is the upper tribunal judge was entitled, given the position before him, to say that just say you have difficulty coping doesn't jump the both hurdles, being both the difficulty, the obstacle, and it being insurmountable.
I'm very grateful. I would respectfully
I think that is what you said.
That's what I'm saying. Absolutely. May I take Lords and Lady to two authorities, and that may assist in relation to the questions that Lords are putting. I mean, first, if I may take Lords to and Lady to tab 2 of the authorities bundle. I'm not sure if you have tabs. This is page 24, where you have the judgment of this court in the case of Mudibu.
Yes.
Yeah, so this is where.
Of course, they're not paginated.
It's not paginated.
So right, we'll find Medibo. Which one is it?
My
Yeah, I
copy
got it.
is actually paginated.
Is yours paginated? 24. Actually, yes, it is paginated. You're quite right. It is paginated.
Yes. 24.
Yes, thank you.
So this is a case where this court grappled with the insurmountable obstacles stipulation following the Supreme Court's judgments on the subject. Yes. Now you'll see from the facts that the applicant was in a relationship with a British citizen, and they made an application on that basis. She was actually married to that British citizen. There is another difficulty.
My paragraphs start numbering at 77.
Yeah. So these aren't the correct paragraph numbers, so I suspect that.
You wanted paragraph 31 or something, did you? Or?
Yes, yeah. So paragraph 77 is in fact paragraph 1.
Yes, I'm assuming that's the case. So we have to add to 77 30.
Yes.
Do we get fined about 107? Is that what we want?
Yes, no, I'll take Lords to the relevant passages by reference to what is there. So this is paragraph 77.
I think this bundle of authority, or the lack of it, is going to go down in legal history. Yes, carry on.
So paragraph 77, this is the first paragraph of the judgment at page 25.
Yes.
They married in 2012, made the application. There was a finding that the requirements were not, the insurmountable obstacle requirements were not met. See paragraph 80. And now you'll see that in that case, the British citizen partner was suffering from HIV. Quite an extreme case. Provided evidence, which is quoted at paragraph 20. Sorry, paragraph 80. I do apologize. Page 25.
Yes, yes.
So HIV, and in addition, he had a fall at work, fractured his arm and wrist, poor health, and so this is the first quotation at paragraph 80, second sentence. So in that case, there was evidence that because of poor health, he would be prevented from employment, as it would be too painful to use his arm.
So where are you reading from now?
Well, this is paragraph 80, quotation in paragraph 80, the second paragraph.
Thank you.
High blood pressure, low vitamin D levels. There was then a second letter which is quoted thereafter. It again deals with HIV, if you look at page 26, you'll see that again provides that he had injuries and long-standing back pain. So quite a compelling case was put forward to sort of meet the insurmountable obstacle stipulation. You have at paragraph 82 the text of the rule in question, and if you then look at page 28 of the bundle, I do apologize, it's page 30 of the bundle, and see the discussion from paragraphs 98 to 102, and I have summarized the analysis in my skeleton argument. And if you then go to page 34, you'll see that even in that case, it was concluded that the evidence wasn't sufficient to meet the test. And see paragraph 107, and that may answer the sort of points that Lords you were raising. So this was a case where it was said that there was inability to work, inability to support in Tanzania, the relative standards of medical care. But then Lord Justice McComb makes a point that
says all the evidence was tenuous in the extreme. Mr. Ali didn't give any evidence at all.
he did not explain what work he had.
He didn't give any evidence.
No, but yes.
At all.
Yes, apart from the evidence that I have that you have just seen. So he did not explain about what work he could have done, etc. No explanation.
There's no evidence of any causes, what obstacles there were, no explanation what his own employment prospects were.
Yes. And
What
so,
are you saying? Those are the facts of that case.
True. So in that case, in the evidence, it was simply said that he's unable to work because of his medical problem. No explanation as to why that was the case. And in my respectful submission, the authority makes it plain that the burden is on the appellant to explain in the evidence as to how the requirements are met, and the sort of matters that were identified were incapable of meeting this very high threshold. So I ask Milady and Milords to compare that case with this case. If those facts were not enough to meet the threshold in question, it's impossible to see how this particular case can meet the threshold. And the point that was highlighted by Lord Justice McComb at paragraph 107 is that the evidence wasn't there. That is the case here. There wasn't any evidence apart from one statement, one sentence from the appellant that I cannot put up with the heat in India.
Does it make any difference that it would appear that these points were not taken in the context of insurmountable difficulty by the Secretary of State before the first tier tribunal?
No, because in my and the second authority core, which I will take you to, may assist in relation to that. It is always for an appellant to provide evidence so to meet the requirements. And take the example of a case where there is no presenting officer present at.
You're saying the burden of proof is on the appellant, and in effect, he was put to proof on the basis that all his evidence wasn't challenged.
Yes.
So far as we know.
No.
There's no suggestion that it was challenged. But your contention is even though his evidence that he couldn't cope with the heat wasn't challenged, that isn't enough to incapable of passing the burden of proof.
Absolutely. And if you then go to page 35 of the bundle, sorry. So this is page 2 of the bundle. You'll see the judgment of this court in the case of Ko. Now this again is an authority that deals directly with the insurmountable obstacle stipulation, and the question of the burden being on the appellant to provide evidence to meet the test. Now that case concerns
Can I just go
India.
I'm just trying to follow through a train of thought. I'm sorry to interrupt you. I apologize.
Yes.
If you're in a first-tier tribunal
Yes.
and let's say for the first time the question of insurmountable difficulty is challenged, so the evidence on this point is as you say, is inadequate, would it be open to the first tier tribunal to say, well, look, this wasn't the subject of challenge, it wasn't the subject of the Home Office's rejection, which was focused on something else. I agree with the presenting officer that the evidence on this is unsatisfactory, but I want to give the appellant an opportunity to address this point, and I intend to adjourn to enable them to adduce point. Could they do that?
Absolutely, it happens.
They could have done that.
Absolutely, it happens with some frequency.
So I'm putting to you, my Lord has put to you, and you accepted Ms. Jones's position, which was actually this wasn't the focus of attention for the evidence on the appeal to the first tier tribunal. That was all about the relationship and the genuineness of it. So if the first tier tribunal judge had done what you say he should have done, which is to say, look, this is inadequate. The evidence you've adduced on this point is inadequate. And Ms. Jones had then said, well, I thought this whole case was really about the relationship. That's why we've given some evidence about it, sort of not enough. I'd like to have an adjournment to put in more evidence. The first tier tribunal would have been in a position to say, well, that's fair enough, I'm going to grant an adjournment to allow her to do that. Could have done that.
In principle, yes, but subject to this point, that in this case, the insurmountable obstacles point was actually taken by the Secretary of State in the decision that triggered these appeal proceedings. So it wasn't a new point.
But I thought it was on the basis that it wasn't an insurmountable obstacle because there was no genuine relationship. There's no reason why you can't go and live there.
Absolutely. But
It wasn't said there's any other, that otherwise it's...
I accept that. So when a person brings an appeal to the first tier tribunal, the first tier tribunal in effect becomes the primary decision maker. The first tier tribunal cannot permit a new point to be taken without giving adequate opportunity to an appellant to deal with it. The appellant may seek an adjournment to adduce
Can we just have a look at the decision letter to see what it said about this? Well, I'm taking you out of your way. I apologise for that.
Yes.
Do you want to deal with call and then come back to this point? I want to just chase this through because I want to see what the reality was before the first tier tribunal. But take it in your own term.
Yes, may I perhaps just show Lord and Milady Co, and
Yes,
I'll then take you to the decision. So Co is a case about an Indian national who made an application on the basis of her relationship with a person and on Article 8 grounds. And this court considered the appeal was state C paragraph 2 to wait for the judgment of the Supreme Court in the case of Agriaku. The discussion about the point that is relevant starts from paragraph 21. You'll again see a summary of the relevant authorities on the subject and an emphasis on the high threshold. And if you then go to the discussion, this is page 17, paragraph 53. Now you'll see that the application for leave to remain asserted, insurmountable obstacles, different submissions were made. That yes, and the submission, the board submission simply was that there were no means to sport. There were no means of sport in India. And may I ask Milady and Lords to read paragraph 54, in particular the second part of that paragraph that appears at page 18, where this court again emphasized that there wasn't any attempt in the evidence to explain the financial position apart from simply saying that there were no means of sport in India. And added that, well, if there were such matters, then one would have expected the appellant to have explained and provided a full picture to the decision maker.
Well, that's true, but I suppose if you say it could be said against you in this case, the present case, that unlike the core case, if you say, if the issue is being deported to, going back, not deported, I'm sorry, if the issue is whether somebody living here who's never gone to India could actually live there, but the issue is primarily whether they would go back, presumably to live with where Mrs. Lal comes from, the Punjab, and he says, well, it's hot there, and I can't cope with the heat at all. I just couldn't cope. And the reception says, no, he just won't be able to cope. He won't be able to cope with the heat here. And the judge says, okay, I don't have any medical evidence on this, but I accept the evidence in totality. That it might be said against you is not merely evidence as to obstacle, but it is at least at first sight evidence that is insuperable. And then the persuasive burden would have to change to the Secretary of State to say, well, true it is that he doesn't like heat, and true it is that it would be, on first sight it would be very difficult, but there are these other ways in which it could be alleviated, because the burden changes. So what I'm saying is, in this case, the evidence of heat and inability to cope with it, it could be said against you, deal both with the question of obstacle and insuperability.
Yes.
And then the burden shifts.
The submission is that the burden always remains on the appellant. It never shifts, in my respectful submission, in this particular context.
But that's a very odd submission. I mean, there are many instances, many in the civil jurisdiction, where what I would describe as the legal burden of proof remains on one party, but the evidential proof goes backwards and forwards.
A classic example would be where the Secretary of State says that the applicant was dishonest. I mean, that would be a sort of classic case where the Secretary of State bears an initial evidential burden. The burden then shifts on the appellant. If he provides an explanation, the legal burden then shifts on the appellant. But when it comes to the rules of this nature, in my respectful submission, it remains always for an appellant to demonstrate that the requirements are met. May I perhaps just ask respectfully?
That means that the difficulty with that is that he or she has to prove a negative, which is notoriously difficult.
Yes,
if you have to prove a negative, that means you have to cover every single. That means that would mean you would have to, in every case, call medical evidence.
Well, there are a number of provisions in the rules that are expressed in the negative. There is a rule which says that, well, there was a rule that if you had no ties with your country of origin, you succeed on your private life grounds. It's not enough for a person to say that I have no ties and that's it. So the burden remains on
what it is, but
that,
I mean, so you are asking the Court of Appeal in this case to say that in a case of this kind, it is impossible to discharge the burden without medical evidence and evidence about where you could live anywhere in India, and the nature of it, because you're proving a negative.
No. All I'm saying is that the evidence that you have in this case,
I appreciate that, but we have to give guidance for other cases as a result of this.
Yes,
The effect of what you're saying to us, you may be right or not, I'm just putting it to you,
yes.
is you're saying, because you retain not only the legal burden but the persuasive and evidential burden at every stage to prove this negative point,
Yes.
You would have to show to the court there is nowhere in India that you could live which has the appropriate climate, or if it's a hot climate, you will have to prove that medically you're unable to live there, and you'll have to prove that there is no alleviating features for you. If it never shifts, you have to cover every possible eventuality of any kind.
No, I'm certainly not saying that wouldn't be a realistic submission. All I'm saying is that an appellant has to provide evidence. So to meet the formulation that I have put forward at paragraph 22 of my skeleton.
But on that, I thought you'd accepted that it could be found on the evidence to be a very significant difficulty. In which case, how was the judge, the upper tribunal judge, able to find that it could be overcome? On the face of it, it couldn't be overcome unless there was some evidential basis for finding that it could.
Well, perhaps if I ask Lords and Milady to look at paragraph 57 of core, I mean that may or may not assist. I mean, again, you'll see that appeal, the Secretary of State's appeal in that case succeeded because Mrs. Gore, in that case, had not put forward anything more than a bare and insufficient assertion of insurmountable obstacle that there won't be any support available in India. And
Well, that just means, as a matter of fact, they didn't accept it was true that there wouldn't be any support available in India.
But if you read paragraph 57 with paragraph 54, I think the point that this court was making was that, well, there may or may not have been an explanation, but the difficulty is that no explanation was put forward.
But I think you are saying in this case, at the very least, there would have had to be medical evidence that Mr. Lal could not live anywhere in India because of the climatic conditions there. I think you are saying that. If the evidence is inadequate, as you say,
Yes.
we've got to consider what would have been adequate evidence at the very least. And I think you are saying, I'm not saying you're wrong about this, I'm just trying to understand what your submission is.
So the submission is that if a person says, I cannot put up with heat in India, no properly directed judge can find that would constitute an insurmountable obstacle.
No, I understand that, but then what would have been sufficient?
Well, that, in my submission...
Because you're saying it's inadequate, that obviously presupposes that there must be, I mean, you accept, I think, that it must have been possible in certain circumstances for the submission to succeed, and what we're trying to find out is, well, what is that? And I think you are saying exactly that if the applicant, Mrs. Lau, put forward evidence that there was nowhere in India where he could live, whatever the conditions, because of the heat, that would have been adequate.
Yeah, no, I mean, I can give perhaps a catalogue of examples where a person may succeed, but it would all be speculative. For example,
We'll deal with this, but why can't we deal with this case?
yes, I mean, for instance, if there is medical evidence, that would be one of the circumstances in which a person may
But it
succeed.
would have to be medical evidence in relation to the whole of India.
No, about the fact.
Well,
that
this
the
is
person-
why I have difficulty with the analysis, because I thought you'd accepted that it could rise to the level on the evidence that was put forward. The judge can't be said to be flawed in accepting that evidence as a very significant difficulty. And the problem then comes in your paragraph 22
Yes.
in saying why it couldn't be overcome. But then surely at least there's got to be some suggestion by the respondent of how it could be overcome at that point, which then needs to be met. I mean, that's where the air conditioning came in.
Well,
Well, why do you say it was, accepting it's a very significant difficulty, why did it fail? Or must it have failed? What further evidence about overcoming it was needed?
Lord, it is for an appellant, in my respective submission, firstly to show that there are very significant difficulties.
Yeah, well, that's what he did, because the judge accepted that, and I think you've accepted that a judge could find that,
Yes.
and it wasn't a finding that no reasonable judge could have reached. So,
Okay.
so what further evidence on overcoming would have been necessary?
Well, yes.
in order to close off that possibility.
Yes, and evidence that would show that the difficulty cannot be overcome without very serious hardship. That is the test.
Yeah, so what sort of evidence about how it couldn't be overcome without serious hardship would be needed?
I mean, for instance, if a person has a medical problem that may constitute an insurmountable obstacle, if there is, for instance, evidence of that the couple would be destitute, for instance, on return to a particular country, that may be another example. Another example would be where there is clear evidence that relocation within the country of return would be unduly harsh or unreasonable, and it is just not possible for the person concerned to live elsewhere apart from a city that is quite hot. One can think of a case where a person is, for instance, at risk.
So the last one was, or if return to a part of the country would be
Unreasonable or would lead to some unduly harsh consequences. For instance, give an example of a person who says that he will be at risk, for instance, in northern India, and for that reason he cannot relocate there. So these are the sort of examples that I can perhaps.
I understand all of those, but the judge didn't deal with those. The judge's example was air conditioning.
No, because
and urban environment. He
no,
didn't mention any of those matters.
No, because nothing whatsoever was put forward by the appellant as to why he could not overcome the difficulty. He did not say at all as to why he couldn't overcome, apart from saying that I just simply cannot put up with heat, and that's it. So that is.
Well, you can't change the weather, so unless it's going to be suggested that you need to change your behaviour, then on the face of it, it is insurmountable, literally impossible.
But I do ask respectfully, I do ask my lords and my lady to consider the implications of the argument. If the argument that my learned friend makes is correct, if a bare assertion that I cannot put up with heat is enough to meet the insurmountable obstacle.
I think what we're trying to work out in our minds is what would have happened in the first tier tribunal if it had been appreciated by everyone that this issue is now a primary focus of attention rather than the relationship one, which seems to be that. That's the first thing I'm interested in, trying to work out what would the judge have done. The second thing I'm trying to work out in my own mind is in the upper tribunal, bearing in mind that the judge should have accepted that there was an obstacle, that the judge at the first tier tribunal found that there was an obstacle, a serious obstacle, and that the issue was whether or not there was sufficient evidence of overcoming it, or of it being an insurmountable difficulty, an insurmountable obstacle. What should the judge have done in relation to that? Was it appropriate for the judge simply, as it were, to treat the applicant as having lost immediately, or should the judge have done one of a number of other things? Should the judge have allowed the appellant, in all fairness, to be allowed to adduce further evidence either before the judge of the upper tribunal or before the first tribunal? That's what I think we're focusing on.
Yes.
We're not suggesting that merely because you say it's very hot, that's necessarily the end of the matter. We're trying to focus on what, in fairness, if anything, ought further to have been allowed to this applicant.
Yes. So that of course is the second of the points.
Shall we move on to that? Because we've had a long time
yes.
on the first.
So in the Secretary of State's decision, the Secretary of State took the point that the relationship wasn't genuine. See page 78 of the bundle.
Yes. This is
Yeah.
Yes.
And then if you look at
Which paragraph are you referring to?
Sorry, if you look at page 78, the last, perhaps if you look at,
Last paragraph?
yes, if you look at page 79, you'll see the ultimate conclusion in the second paragraph. It is not accepted that you and your partner intend to live together permanently in the UK because your relationship is not deemed to be one which is genuine and subsisting.
Yes.
That was the first point.
I mean, that was the only reason, actually, why it wasn't accepted under the 5-year route. So I'm not quite sure why there was a further hurdle then to overcome for the 5-year route. Because the Secretary of State simply on the 5-year route never took any other point.
No, that is true. So
But the Secretary of State could do so in the tribunal, you say, and say, well, even though that my reason for refusing it under the 5-year route was wrong, there was another hurdle which you failed to provide proof of.
no, but in fairness, I think the Secretary of State did not take the point even in the first year tribunal. The Secretary of State did not say that the financial requirements were not met.
Well, why wasn't the appeal correctly allowed then?
Because Miller and Friend told the court that it was accepted that the financial requirements were not met, and I assume that only was the reason why the judge proceeded to consider the insurmountable obstacle stipulation. There wasn't any other reason.
But I have difficulty with that, because if the Secretary of State doesn't say that you failed to meet the financial obstacles, it's not for the first tier tribunal to start taking that point. Indeed, if what we're told is correct, I'm not quite sure whether those financial matters actually come into Article 8.
No, absolutely. Yes.
Perhaps I could assist, my lord, because I was there, and that is that on an appeal it is for the appellant to prove that she meets the immigration rules. And an appellant, or counsel representing an appellant who knows that there are details under Appendix FMSC which have not been complied with, couldn't put forward a positive assertion to the tribunal that all aspects of Appendix FMSC are met.
So did you say to the first tier tribunal that the financial requirements are not met? Did you say
It wasn't that the financial requirements were not met, but that all the details of Appendix FMSC had not been complied with. I couldn't have asserted to the first tier tribunal that they were, because
But is that part of the test under Article 8?
not under Article 8.
Well, you're telling us that in fact that it was only Article 8 that the first tier tribunal was allowed to consider.
But when the first tier tribunal was considering it under Article 8, initially it would consider whether the test under the immigration rules was met, because if it is met, it would be a breach of Article 8 not justified.
And that test includes the financial requirements, does it? For this purpose as well?
Yes, everything under Appendix FM, including all the references to Appendix FMSC, and if your lordship's never had to read it,
Can you
your
just,
lordship's
was there any evidence about the financial requirements point for this for our judgment? What is the evidence about the financial requirements not being met?
There are very detailed requirements
No,
about...
but any evidence? Or the judgment before us?
It's not mentioned, there's no mention anywhere that I found in the bundle of the
It's not
financial
mentioned
requirements.
anywhere,
Not
because
mentioned in the letter from the Home Office, not mentioned in the
It couldn't be
FTT.
asserted by the appellant at the hearing that all the requirements of Appendix F...
No, I understand that. You're telling us they couldn't in fact be met.
No, the income level was sufficient, but there weren't the documents that are required under Appendix FMSC in terms of accountants' letters and so forth.
So the income level was met,
Yes,
but the evidential requirements were not there.
yes.
Can you give us the particular provision?
I'd have to look it up. No, I can't remember off the top of my head, but
Yes.
I can check that, my lord.
Thank you. Yes, thank you.
Lord, the Secretary of State hasn't taken any issue with that, and if Miller and Friend hadn't raised it, I would have conceded without hesitation that the appeal succeeds simply on the basis that paragraph EX1 has no application at all, because all other requirements are met. But the rules provide that if financial requirements are not met, if you are an overstayer, then paragraph EX1 applies.
Even if you're under the 5-year route? Because that's a requirement that everybody has to meet, whether under the 5 or the 10-year route.
Absolutely. So I have, of course, taken instructions on this point, and I emphasize with respect that I'm not, the Secretary of State is not saying to the court that
A very reasonable
that the
position.
financial requirements were not met at that point.
Yeah.
It wasn't ever taken.
Okay.
But you heard what Miller and Friend said, and if that is correct, then it is common ground that EX1 applies. So there is then an appeal to the first year tribunal. The appellant recognizes that, concedes that.
We're on the letter at the moment. Where in the letter is the heat issue addressed? The heat issue, it's not there.
It's not. I think the only reference is bottom of 79 I could find, which says that your relationship with your spouse is not deemed to be genuine subsisting, and therefore there are no insurmountable obstacles.
That is that. And then if you also look at page 80 of the bundle, in the context of a different provision but dealing with a similar subject matter, the Secretary of State concludes that, well, the appellant has lived.
Where are you looking at now? Which paragraph?
Last paragraph at page 80.
But that's talking about the appellant's reintegration to India. No, she's not suggested she has any problem with the heat.
Yes, so the heat issue, I'm not sure if it was...
Well, it didn't arise. The reason it didn't arise is because they didn't accept it was a genuine relationship.
The heat issue, I suspect, wasn't even raised by the appellant in her application for leave to remain to the Secretary of State. It was raised for the first time, as I understand, and friend will correct me if I'm wrong, at the first year tribunal. So there is then an appeal to the first year tribunal. The appellant goes to the first year tribunal, of course, prepared to deal with the main issue, but she also recognizes, on the basis of what you heard, that the financial requirements are not met, and for that reason,
She wants a finding of insurmountable obstacles.
yes, and she provides evidence in support of that assertion, the evidence that we have seen in one sentence. And the appellant wouldn't have provided that evidence unless she had recognized that paragraph EX1 was applicable. So there was, the appellant had, in that sense, notice of the point, adduced evidence, the judge considered the evidence, accepted that. There is then an appeal by the Secretary of State to the upper tribunal. And this is where difficulty arises, and I may, perhaps I will seek Lord's permission to provide you the practice direction that the senior...
I'm just concerned, I have to rise at 1:45.
Yes.
And you've been talking, it's not your fault we've interrupted you a lot.
Yes.
And asked you questions, but I think I'm going to have to limit you to a maximum of 1/4 hour now.
I'm grateful for that, yes. So, Lord, three points that I can make about what happened at the upper tribunal. The first, my Lord, is that there is no suggestion that there was ever an application by the appellant made to the upper tribunal that she wished to put forward any further evidence. Subject to the court's permission, I will forward an authority this afternoon of this court, where this court said that where an appellant wishes to rely on evidence that wasn't before the first year tribunal, that appellant is required to put in an application notice to the upper tribunal explaining the significance of the evidence and why he or she wishes to put it forward. So no application was made here. The second is that the general expectation, in line with the senior president's practice direction, which again I will forward to the court this afternoon, is that the upper tribunal, when it set aside the decision, will proceed to remake the decision, and will remake the decision on the basis of the evidence that is on the file.
Even when there's been oral evidence on the point.
Sorry?
Even when there's been oral evidence on the point,
Yes.
which the upper tribunal won't have heard, obviously.
No, yes, but the upper tribunal in practice would have the record of the oral evidence. The first year judge would have taken that record. The upper tribunal gets the same file. So that is the expectation, and the practice direction also emphasizes that because that is the expectation, it is necessary for an appellant, if he or she wanted to rely on further evidence, to put in that evidence with an application. Yes. So nothing was done to that effect. Thirdly, and again perhaps at the risk of giving evidence, the general practice of the upper tribunal is that before it lists the matter for hearings, it usually sends out standard case management directions, which would refer to the senior president's practice direction and would say that, well, the upper tribunal is going to make a decision on the basis of the information that is on the file. If there is anything else, then you got to put that forward now with an application. So again, with your permission, I'll seek to identify if if ever there were any standard directions issued in this case.
I accept.
Yes.
I accept.
Beautiful. So Miller friend has helpfully indicated that she accepts all three points.
It'd be helpful to have the practice direction if you could send it to us often.
I'm very grateful. So, and then again, perhaps you'll see the point in the authority that I'll forward you. I mean, the scheme of the first year and the upper tribunal, the expectation has always been that the upper tribunal will remake the decision. I mean, that was in effect one of the reasons why the upper tier was created, because of the concerns that this court had expressed, that the matters would go back to the first year tribunal, there would then be an appeal. So in my submission, it was not objectionable in that context for the judge to remake the decision on the basis of what was before it. And what was before it was incapable, in my respectful submission, of meeting the high threshold. Now this takes me to the third and final point, which concerns Article 8 outside the rules. Of course, you have the comment by the judge at paragraph 9 that the only issue was about insurmountable obstacles. It appears to me that was the only issue on which submissions were made, but I of course accept that at paragraph 11 the judge deals with the claim outside the rules. He makes the point that the essential requirements of the immigration rules are not met. He then says that, well, under section 117b4, little weight is to be given to the couple's relationship because when the relationship has been entered into, the claimant's immigration status was precarious.
That was wrong, wasn't it?
That was wrong, obviously, but it makes no difference on the facts of this case. And may I take my lord to just one authority that deals with this point and would demonstrate why the error is not material to the outcome, and that is TZAD Pakistan. You have that at page 35 of the authorities bundle. Now this again, a similar case in the context that there was an Article 8 claim based on a relationship and marriage to a British citizen. And if I may take the court to paragraph 41. Yes. Yes, I think it's page 41, if it assists.
Page 46.
Paragraph 41, did you say, or page 41?
Paragraph 25, which
Paragraph
is
25.
page 41. Now, you'll see, if you look at paragraph 25, the settled jurisprudence of the ECHR is that it is likely to be only in an exceptional case that Article 8 will necessitate a grant of leave to remain, where a non-settled migrant has commenced family life in the United Kingdom, when his or her immigration status is precarious, not unlawful. So the fact that the appellant was living here lawfully doesn't matter, because it is common ground that her immigration status was precarious.
But how do we square that submission with the clear distinction, which is obviously deliberately drawn in 117,
Yes.
between unlawful and precarious people, where in one case it's only the private life that
Yes.
we're in precarious, and
Yes.
on your submission it should be read almost as though it says in the same terms in subparagraph 4 as in 5.
This is what this court said expressly in my respectful submission in this judgment. I mean, the essential point is that...
Well, did they address 117?
Yes.
Yes, they did later.
Yes, I'll take it there. But if you look at paragraph 25, so I've shown you the first sentence, and if you then look at the second last sentence just above the quotation, both the unlawful overstayer and the temporary migrant have no right to remain in the UK because they enter into a relationship with the British citizen during their unlawful or temporary stay. And then the senior president says that this is the principle that was accepted by the Supreme Court in Agriaco. And you'll see that that concerns...
Well, the temporary migrant might be read as somebody who's got temporary admission,
No,
as opposed to somebody who's got leave to remain, albeit for a fixed period of time.
No, Lord, but if you look at the quotation, you'll see that with respect cannot be right, because the Supreme Court was talking about cases, precarious family life cases, where very strong or compelling claim is required to outweigh public interest.
Where does it make? Where does is the difference between 117 B 4 and 5? Where is that explored? Where's
Yes.
that explored?
So this paragraphs 25 and 26, the senior president there is not dealing with 117B. He deals with 117B thereafter. But in those paragraphs, he is saying that, well...
Oh, I know that, but I'm asking you the specific question which we're putting to you, is that
Yes.
the immigration rules plainly make a difference between, they plain on the face of them are making a distinction between the weight to be given to a relationship where on the one hand it's while during a period of unlawful stay, and the other hand where it's simply precarious. They're making a clear distinction there. Where is that addressed here?
Yes. Well, first, you've seen paragraph 25. If you then look at paragraph 26, now you'll see that Agriaco, this is the third line, overtly recognized that precariousness includes both those who are in the United Kingdom unlawfully and those who are here temporarily.
Yes, well, that
But
goes
what
to
does
section
temporarily mean? You say it means anybody without indefinite leave to remain?
Yes,
So
because
if you've got a 10-year leave to remain, that's precarious, is it?
yes, because if you read on, my lord, that particular paragraph, you'll see that there is then a reference to rupiah, which the senior president says is
I
binding.
don't, I,
Rupiah
don't have, I
says
don't have a doubt about that, but that all goes to subsection 5.
now, if you, yes, so that's that. And if you then look at 27, this is where the senior president links the earlier case law with section 117B.
Okay.
And this is what he says. In every consideration, this is third line, in every consideration of any requirement of the rules that possesses an Article 8 element and of Article 8 outside the rules, if the applicant's immigration status is precarious, then little weight is to be given to private life or to any relationship formed with the qualifying partner. So the senior president says that yes, the statute makes the distinction, but that does not mean that if family life is established when a person's immigration status is precarious, that family life is to be given any greater weight. The position remains that as a matter, irrespective of what section 117B says, little weight is to be given to a relationship formed with a qualifying partner.
But actually, section 117B doesn't say that little weight's to be given to family life that's established when immigration status is precarious. It's simply not what it says. It says that about private life.
Yes, but the jurisprudence says that that would be the approach that would be applied not only to private life but also to relationship forms with the qualifying partner. Just take this example, Lord. And I asked Lord and Lady to consider what perhaps was the position before section 117B was introduced. Of course, it wasn't. It was always the case that if the relationship was formed when a person's status was precarious, then that relationship would attract little weight. But what the senior president said at paragraph 27 in my respectful submission could not be clearer.
Well, I just don't see how that he can say that as being the effect of section 117B unless he's rewriting it.
Well, I mean,
With respect, as one says, to the senior president.
I think this case was an example of the difficulties that arose from the language used in section 117B. There were arguments pursued by the appellants that, well, see, the relationship was established when I was living here lawfully, and therefore you got to attach greater weight to my family life, and that was the context in which these cases come before the court. And the senior
Right.
president says that, well, you have to look at 117B in the light of the jurisprudence, the earlier jurisprudence, and this is what the position is. I mean, so I
suppose another way of analysing it might be to say Section 117B doesn't cover the whole ground, and even apart from 117B, that's the position.
Absolutely. So if what the senior president says at paragraph 27 is to be followed, then what the upper tribunal has said in this case is not objectionable at all. And again, just going back to paragraph 30, page 38 of the appeal bundle, paragraph 11 of the upper tribunal's decision. So the way says that the section 117B4 requires me to attach little weight to the couple's relationship. The reference
where did the upper tribunal consider whether this was an exceptional case or not?
Well, at paragraph 11, there last sentence, there are no compelling circumstances, because no compelling circumstances were identified in the evidence. There wasn't.
Yeah, but this is a 73-year-old man who has never been to India, who has all his family here. Where was that considered?
Well,
why was that not exceptional circumstances to require him to maintain what was a genuine marriage and loving relationship, that he had to go to this continent he'd never ever lived in his life? Where does the judge consider whether that was or was not exceptional?
Well, the judge, in my submission, can only consider what is put forward in the evidence.
That was there on the papers. I mean, it's one thing to say that, okay, the heat won't preclude it.
Yes.
But under Article 8, we're concerned with a much wider circumstances.
Lord, again, with the greatest respect, I mean, that is the effect of all these authorities, that the rules are compatible with Article 8. So if a person fails to comply under the rules, it is unlikely that he will have a good argument.
And if it's exceptional circumstance, you can't say that Article 8 that it only turns on the rules. That certainly is not the case.
Absolutely, but what I'm saying, adopting what the Supreme Court said, that it's unlikely that a person who fails under the rules will have good grounds to succeed under Article 8. Of course, if there were any compelling evidence, compelling circumstances that were put forward, one would have one would have expected.
And the issue then is whether, although the judge doesn't address the question of exceptional circumstances,
well,
the question is whether, as a matter of law, it is right. He was right to simply assume that because there was no reason as a matter, because of his health, why he couldn't go to India, that he was right to assume that therefore there were no exceptional circumstances.
Well, he deals with age, and he deals with family and friends.
I mean, is the approach that on the Article 8 we make our own minds up about that? We don't give deference to the judge's view, or do we?
No. I mean, of course, the question for this court remains whether the decision taken by the upper tribunal fell within the range of reasonable responses. So it's not with respect for this court to...
Is that right on Article 8, is it?
Yes.
I mean, outside the rules.
That is the case, yes. I mean, it's
not normally the case on human rights points that you have to show that the decision maker was wrong. Normally the court, at every level, I thought, decided whether something was unlawful in the Human Rights Act.
No, again, Lord, with your permission, I'll forward you an authority that is directly on this point.
Yes, please.
Making it plain that on an appeal to this court, it is not for this court to make its own assessment about the proportionality, but the question is whether the upper tribunal has made a legitimate decision.
Okay.
But yeah, so I will of course forward that.
Yes, please.
This afternoon. But my submission is that even if that isn't the case, and this court is to form its own view of the evidence that was before the upper tribunal, it cannot be said in my submission that there are any compelling circumstances. I mean, again, with respect, not that I do not recognize what Lord Master of the Rolls is putting to me, but that cannot amount to a compelling circumstance.
PG India was a case where PG arrived on the 10th of June 1989. was born on 10th. She arrived on the 19th of July 2012 with a visitor, with a clearance until the 21st of December that year, and she entered again on the 20th of September, and on the 2nd of October she met this man and they married on the 8th of November.
Yes.
But that bears no comparison whatsoever to this case.
Of course, I recognise that the facts are different, but in this case, I ask Millennium Lords to consider if any compelling circumstances were actually identified in the evidence, apart from the 3 points that we have looked at: heat, age, and family and friends.
Yes.
And if this court is to take the view that the requirements of the rules were not met, but those 3 points were sufficiently compelling, so to bring a person within the ambit of Article 8, in my respectful submission, that would be inconsistent with the authorities. And again, I make this submission with great respect, that no properly directed judge can find that these 3 matters are sufficiently compelling to outweigh the public interest. The public interest being in having an effective immigration control and system of the rules that is workable.
Immigration controls contain Section 117(b)(5) and 4. That's part of the immigration rules, and they make a distinction.
Yes,
That's the immigration. That's what Parliament has laid down.
yes, but they do not cover everything, and you have seen what the senior president has.
Can I just ask you
Yes.
quickly about in dealing with insurmountable obstacles, should one not in fact look at the 3 points collectively and decide whether together it's the heat, the family ties and age that amount to serious hardship, and rather than picking them off one by one?
Yes, yes. I mean that. What a judge. I mean, of course, the judge has to deal with the points one after another, which he has done, and then the ultimate conclusion is at paragraph 11 that it would doubtless seem harsh to the applicant and the husband. The decision.
Well, that's almost acknowledging that it would be amount to serious hardship at the, or perhaps not. You say not. It's just
the judge simply says this would seem harsh, but he then concludes that
that's the way it goes.
the insurmountable obstacles stipulation is not met. So the judge there is just looking at everything globally and coming to the conclusion that none of the factors identified, even considered in isolation or together, are enough to meet this very high threshold. So unless I can assist you any further, these are my submissions.
One more question: what happens if the appeal is dismissed? I mean, how does the child come into it? Is there a new decision on can a new application be put in which, for example, the financial requirements evidence could be provided or not? Is that can't happen?
I can say this. I've taken instructions that if the appeal is dismissed, the Secretary of State is not going to remove the appellant from the United Kingdom. The Secretary of State will review the case. There is no need for the appellant to put in any further application for leave to remain. The appellant has put forward a one-stop notice. The Secretary of State knows that there is a child. The Secretary of State will look at all the circumstances, will make a new decision. And I mean, I perhaps cannot say much in disagreement to what my learned friend has said about the child. Section 117(b)(6) says that if there is a child, British citizen child, the public interest would not require the parent's removal if it is not reasonable to expect the child to leave. The Secretary of State's practice is that it's rarely reasonable to ask a British citizen child to leave. So in practical terms, I'm not saying that the applicant will get leave to remain, but the Secretary of State will make a decision even if the appeal fails.
Right.
If the court finds that the upper tribunal's decision is wrong in law, the court can then consider whether it is appropriate to remit the case or just leave things as they are, because the Secretary of State is going to look at the matter again and make a new decision.
Which could then be challenged if it was adverse.
If it is adverse, yes, that will trigger an appeal.
Thank you very much. Yes.
I appreciate the time restraints, my lord. Your lordship asked for the details of why it could not be asserted that the appellant met the requirements of Appendix FM without EX1. I've looked up, and the requirements that were not met were Appendix FM-SE, capital A1, dot 1, dot open brackets A, close brackets, open brackets, Roman numeral 3, and A1.3, dot open brackets E,
A1.3, yes, okay.
dot open brackets E, close brackets, open brackets, Roman numeral 1, close brackets, open brackets 3, close brackets, open brackets little b, close brackets, and I was not responsible for the numbering system, so it couldn't have been asserted.
A1, sorry, A1.CE dash, is it? A1.
A1 3E little Roman 1 3B.
Yeah, A3, 3E. Yes, thank you.
And that's why I couldn't remember off the top of my head. I have very little else to say, and
I'm interested to know what you do say about this case.
about which case?
TZ Pakistan.
TZ Pakistan involves a person who didn't qualify within the meaning of the rules. There were two people in that case. The evidence was given in the TZ case by TZ saying his partner would be unable to support herself financially and would not be accepted into Pakistan if she were to join him. That evidence was given by TZ about his partner. And in the second case, PG India, her position was completely different from the appellant's and her husband's in this case. And Section 117B of the Nationality, Immigration and Asylum Act is considered, but the tribunal doesn't appear to have looked at the difference between 4 and 5. It's not referred to at all. And in my submission, the statutory language is plain.
Can we say, it's binding on us though, is it?
Is what binding on you?
The case is binding on us. Is it binding on us that in both cases, that was a case where the facts, certainly in PG India, the facts fell within 5 and not 4.
It's not entirely clear, but probably it did.
So in that sense, it's the same as our case.
Yes, although her leave would not have been extended under Section 3C as a visitor, because a visitor cannot make an in-country application as a spouse. So there is a lack of clarity there. If I had to pick one, it would probably be 5, but I don't feel I can say for certain that it would be.
So it might not. You're saying it might be 4.
It might be because.
Why would that be?
Because a visitor can't switch in country to a spouse. So Section 3C.
Shall I say that again? Visitor cannot
make a switch in country to a spouse visa. So Section 3C leave wouldn't have continued as a visitor.
Therefore, 3. What wouldn't continue?
3C leave.
But that doesn't matter if the position as a matter of law is that anybody who doesn't have indefinite leave to remain is treated as precarious.
That's right. So. I beg your pardon there. My learned friend was just kindly referring me to TZ's case. It does appear that TZ did have temporary leave to remain, so would have fallen within 5. What doesn't appear to have happened, though, is that the court considered the differences between 4 and 5 because they're using the language of 4. Very little weight.
Well, that language appears in both 4 and 5.
Yes, but I beg pardon, to family life only.
It only refers to, it doesn't refer to relationship.
No.
There's no reference here to relationship.
No.
Right. So is the position, because certainly PG India, the relationship was very, very short.
Yes,
That's right, isn't it?
it is. My lord,
She met him on the 2nd of October 2013, and they married on the 8th of November. So she met him for the first time 1 month before she married him.
yes,
Right.
and that's set out in paragraph 41. It was not, it couldn't be described as a long-term and settled relationship, although I understand that she was pregnant from the case.
At the time of the UT hearing, she was
Yes.
pregnant.
Not at the time of the application.
That's a different matter.
Yes.
And what was can we just look at the TZ Pakistan?
The facts of TZ Pakistan.
Well, I'm just trying to think, because we're concentrating now on 117B4 and relationship with a partner.
They met in February. They started a relationship in February 2013.
And moved together.
Moved in together in September 2013. And when his Tier 2 general visa was refused, he tried to
March
he then
2014.
relied upon the relationship in October 2014.
That was the first year tribunal, but the refusal was in March 2014.
Yes, but the refusal was on a student. On a work permit.
So he relied upon it for the first time in the appeal.
It appears so. Yes. Do you agree? Do you agree? He didn't make an application on the relationship. Yes, he didn't make an application based on the relationship. It was raised under Article 8 on the appeal.
Right. Good. Anything else?
I think the problem you've got is that the Rupiah case, if I remember it, says that you are treated as precarious, even if you're on
I accept that is
temporary.
correct.
But
It
would
does
one
say
way
that.
through this be, because you can't ignore the rules completely, that yes, it all depends on the facts, and the question is, at the end of the day, as the judge says, there has to be an exceptional case,
Yes, my
and
lord.
that those 2 cases were not exceptional. And the question really is, in terms of the relationship, 117B4 cleanly recognises that even in a precarious situation, in appropriate circumstances, weight can be given to a relationship.
Yes, my
I mean,
lord.
that must be right. Otherwise you're simply rewriting the legislation.
Because
For what the gloss is, the case gloss is, it still has to be an exceptional case.
yes, my
But
lord.
in an exceptional case, weight can be given to a relationship,
Yes, my lord.
more so than in a private, than something else.
Because of Rupiah, as your lordship referred to, precarious covers everybody from someone who arrived yesterday on a visitor's visa to somebody who's been here for 16 years on all sorts
So
of
the
visas.
question is, in that context, are the facts here sufficiently exceptional to give weight to this relationship?
Yes, my lord.
Not what might happen to the rest of the private life, but this relationship.
Yes,
That's really the question, isn't it?
it is.
And the question is, did the judge of the upper tribunal deal adequately with that issue, aside from the question of heat?
Yes, my lord.
Is that what we should be looking at on this issue?
Yes, my lord.
Did he adequately address the question under Article 8 of exceptionality, or did he simply wrap that up into the question of heat and insurmountable obstacle under the rules? That's the question.
It is, my lord, yes.
Okay. Anything further?
One sentence, as I know your lordship needs to rise, and that is that my learned friend referred to the evidence in this case being a bare assertion. I can't cope with the heat, but he gave oral evidence. There was cross-examination and judicial findings, so the evidence was not a one-sentence bare assertion that was before the first tier. Thank you, my lord.
Thank you both very much indeed. Just to remind you, I would like to hear from your solicitors, please.
Yes, my lord.
Thank you both very much indeed.
The FTT or the UT.
Oh, he didn't say, but presumably because I said, is it finished yet?
I don't know where to burn it.
Did you get my brush, did you?
Copy you in my email.
Thank you.
Yes, I mean, with all of those things except being true. Also, the idea that you get a journal is easy. Somebody who's...
Or even if you don't apply for enjoyment, again the first year simply say that you haven't dealt with this point adequately, and I adjourn and you deal with it.
What the FTT tend to say is you've got one broken leg, well, you've got another one.
Yeah.